Hello and welcome to Securing the Future, Legal Strategies to Protect Patent and Profit from Innovation. My name is John White. I'm a patent attorney at Harness IP, and I will be your moderator MC for the next fun-filled half hour of discussion about intellectual property and the rights that can be obtained. And our object is talking about the future. And the reason you talk about the future when you talk about intellectual property is that's what intellectual property does. It gives you a seat at the table of the future by securing your rights today. The sweet spot for ownership, enforcement, monetization is 5 to 10 years out, and we help you get from here to there on whatever budget you have in mind. So let me begin by introducing the firm. Harness IP. You probably think we made that name up. We did not. It was actually the name of our founder, Harness, and he set up a patent department. This is our origin story, as they say. He set up a patent department for a guy named Henry Ford, probably a name you remember. He then went and set up his own firm in the General Motors building and did all of Chrysler's work for the next 40 years. What conflict, right? Those days were a golden age of doing whatever you wanted. In any case, a highlight more recently is our firm. It's about a 100-lawyer boutique. Took a case from district court to the Supreme Court and took a unanimous decision away. And we're the only patent firm that can say that has occurred within the organization. We've been highly ranked for years and years and years. And by now, everything that we've ever done is in the thousands. So tens of thousands of patents, tens of thousands of trademarks, tens of thousands of literally everything. And so the point being, if you need advice, we can provide it. That's Harness IP. We have offices in DC, Detroit, St. Louis, and in Dallas. And technology is our business, just like it's your business. And remember, as a patent attorney or patent person, all of us are engineers and scientists first, and then lawyers second. So whatever technology you have to talk about, we have answers for you. Let me introduce you to some of the people here with me. To my left, we have Kevin Mierzwa. He's out of Detroit. He started out at Ford Motor Company. He's a double E. And so he will tell us all about obtaining rights. And then further to my left, we have Doug Robinson. He's out of St. Louis. And he's our enforcement guy. Once you have these rights, how do you turn them into action and or money and or any other business leverage that you would like to obtain? And then, of course, there's me. You already know me. But what I do is I teach others how to be a patent attorney. I've taught about 35,000 of them at this point, and I'll probably continue doing that for a while, but that is what I am known for. All right, what we're going to cover today, first of all, you may have stumbled upon this, or basic fatigue has brought you here, or interest has brought you here. But regardless of the reason you sit in that seat, you need to know about intellectual property. We're going to cover the basics. We're going to talk about how the environment is changing with respect to statutes and what can be covered. So what you protect, how you protect it is always evolving. We're going to talk about AI because we can't not talk about AI, right? It's literally on every booth in here, something about AI. And we're going to talk about going the other way. What happens when someone's looking at you for potential infringement? And lastly, we're going to talk about money, money, money. The reason we do anything, right? You're not doing this for free. You're hoping you're going to make money at the end of the day. And so, speaking of money, let's start with our first topic. And Kevin, how about a real world example of why and how intellectual property may matter?
Absolutely. Thank you, John. VCs and private equity typically get involved in various stages of product development. So they have us investigate the protectable rights. The protectable rights, if they've been out for more than a year, are not protectable in foreign countries or in the United States. However, if they've been out less than a year in the United States, then we can file a patent application in the United States. A quick example is I was involved in a product that VC was looking at. Their main product, not really any improvements, and the VC actually withdrew and did not support the product because the product was out for more than a year and a half. So it's important to get those applications filed.
Right. And that's the message. The first message we want you to take away is you can't react in IP. You have to anticipate. You got to be there before the rest, and you have to take advantage of and capitalize on that. So let's start with the first generalized topic, copyrights. Kevin, tell us about copyrights.
Copyrights are a really inexpensive way to protect a lot of things. Once you form the work and fix it in a tangible medium, you have a copyright that affixes. But in order to enforce your rights, you need to have a federal registration. Federal registration can be obtained in just a matter of months, so it can be pretty quick, and they last for a long time, 70 years from the last author's death, or if it's an anonymous work or a work for hire, 95 years or 120 years, whichever's shorter. In the broadcast industry, we typically think about TV shows and movies being copyrightable, but there are other things, especially when you look around this room and you see the computer programs and the software that control the products, websites, graphical user interfaces, and the like. Those things contain icons, graphics, layouts, color schemes, and screenshots that may be protectable by copyrights.
Now, what happens when it all goes wrong, Kevin, and you don't quite get all the rights you thought?
That can be a pretty tricky situation. So in this case, everybody thinks of Nike, the swoosh, for example, as a logo. The logo was developed by an outside company for Nike, and Nike had started using the logo for a long time. And it wasn't until later that they realized they didn't own the copyright for the logo since somebody else outside the company did that. And I was told that in the 7 figures is what Nike settled for obtaining their copyright.
Yeah, so the message here is know what your rights are and know how to protect them and how to secure them up front while everyone is still shaking hands and talking and, backslapping and all that. Because I can assure you when you get down the road and real money's at stake, real money will be at stake. So work it out where everyone's still friendly. Okay. Now, what about enforcement, Doug? What happens there?
Yeah, thanks, John. So the question is, why would Nike have to pay that large sum of money to obtain that, the rights to that copyright in the swoosh? And the answer to that is, because the law allows, in cases of copyright infringement, allows the copyright owner to sue the infringer. And the law provides for a variety of different types of what are called remedies, in the case of infringement. The first and the one we think about most often is damages. There's statutory damages under the copyright statutes. It's set a floor. Actual damages are also possible. And these damages can be real money. For example, right now, there's a copyright dispute going on where the New York Times has sued OpenAI saying that copyright infringement occurred based on OpenAI's use of New York Times articles to train the AI system. And this is not the only example. There's examples using Microsoft's Copilot, ChatGPT. A lot of AI companies are being sued under this same theory by publishers who own copyrights. And in the case of the New York Times case, damages have been calculated potentially in $100 billion plus. In addition to damages, in cases of copyright infringement, the law allows for a recovery of attorney's fees by the plaintiff, which is relatively unique in the U.S. system, and also allow for injunctions, which is a court order stopping the infringement. And you look at the case, for example, of an OpenAI or a ChatGPT. Well, is it possible that these AI systems could be shut down by the courts based on infringement of copyrights? The answer is maybe. That could possibly happen. Remains to be seen. But the copyright laws allow for that sort of thing in the form of an injunction. So the remedies available for infringement are very powerful.
Yeah, you need to keep in mind when you're talking about AI that it's nothing like that until it gets trained. And I can assure you that everything on every screen here is going to train something to do with AI in the future. If not, your face is being looked at right now and training something somewhere. So whether you like it or not, we're all going to be training something, and those are rights. Okay, you aren't free. All right, next up, there's some trademarks, there's some copyrights that spill over into multiple baskets of protection. Kevin, tell us about trademarks.
Yeah, trademarks give you a little bit different coverage in terms of your intellectual property. They're words, symbols, or devices that identify your product or services. When you look at this slide, Coca-Cola, for example, has a word mark Coca-Cola. They also have the logo Coca-Cola, but people don't think about this. They have the shape of the bottle as a trademark. Trademarks don't have to be registered, but in order to get the most rights out of your trademarks, they should be registered. There is common law rights that do exist, though very limited in the state and federal government. It takes about 9 to 12 months to get a trademark through the trademark office and for an allowance, and about another 3 months or so after that to get your actual registration. One nice thing is that the trademark office allows you to reserve your name, which is, they call that an intent to use application. So you can file a trademark application if you think you're going to be using it within the next 3 or so years. You have 3 years from the time it becomes, or 3 years from the time it becomes allowed in order to show your use to perfect your rights. A nice thing about trademarks is they can last just about forever. The Coca-Cola trademark, for example, was registered in 1893 and is still going strong because they continue to use it.
Yeah, a lot of IP rights are bottomed on use, and this in particular, trademarks are bottomed on use in the United States. In other countries, maybe not. So if you're projecting worldwide, make sure you know the rules in the countries you plan to engage in. All right, what happens when it all goes wrong, Doug?
Well, similar to copyrights, the law allows for remedies in the case of trademark infringement. And generally, when we talk about trademark infringement, it's usually the concept of the infringer is playing off the goodwill of the name of the trademark holder. For example, there was a case in the last few years where there was 2 security monitoring companies. The plaintiff had a trademark that it owned in its name, its services. The defendant was apparently out there pretending essentially to be the plaintiff, using the plaintiff's trademarks to fool people into signing up with the defendant. Well, this ultimately resulted in a damages award of $190 million. So you can see, like with copyrights, trademark laws allow for significant damages in the case of infringement. What the trademark laws also allow for is destruction of infringing products and also exclusion of infringing products from importation. Also, injunctions are allowed to otherwise stop the infringement. And I'll go back to the point of the destruction or exclusion of infringing products. That's important, especially for gray market goods. Trademark law can be very powerful for limiting the prevalence of gray market goods. I know we all know situations where it's a company's own product authorized for use or sale outside the U.S. somehow finds its way back in to the United States. In that instance, trademark law can be used by the company to stop that. There's also a related aspect in trademark law that's slightly different called dilution. And what dilution essentially is where a infringer is not so much competing with the trademark owner, but rather tarnishing the goodwill that the trademark owner has built up in its name. And there was a recent example involving Jack Daniels where there was a pet supply company who was offering a squeaky toy called Bad Spaniels. And it obviously, you see the pictures, it sort of played off, parodied the look of the Jack Daniels bottle. Well, Jack Daniels viewed this as tarnishing its good name, sued, and ultimately obtained an injunction to stop this pet squeaky toy under a dilution theory. Now, of course, nobody thought that Jack Daniels was actually selling this product, but trademark law still nonetheless allowed it to stop this product.
But of course, the reason you're in your seat is the patent stuff that we're going to talk about, and that's next. So patents, what are they, Kevin, and what are they useful for?
The interesting thing about patents is they allow you to prevent others from making, using, selling, and importing into the United States. The tricky thing is the prevent others part. The prevent others part doesn't necessarily give you the right to do something, but rather prevent others from doing it. So if you have improved somebody else's product, you might be patentable, but you might not be able to practice the underlying invention. Like I mentioned earlier, it's very important to get your disclosures on file before you're going to release your product. This allows you to have both U.S. and foreign rights. The U.S. gives you a 1-year grace period from the time if you release a product in a non-confidential way to file your patent application, but you'd be barred in other countries. The nice thing is the other countries do recognize the U.S. filing date as a filing date in their country, as long as the specific treaties are followed.
Right. And, the one thing people don't recognize is that most patents are improvements on what exists. Thomas Edison didn't invent the light bulb. He invented the light bulb that would last. And as I look around this show, I see an awful lot of stuff that it's an improvement on what exists. That is all protectable because it's the result of creation. It's the product of your mind. And that's what intellectual property is out to protect. And so what about the types of patents?
Well, the two main types of patents are utility patents that protect the functionality of something. They last for 20 years from the time that you file. Design patents protect how something looks, the appearance of an article. And the protection on that lasts for 15 years from the time it becomes issued from the patent office. A special type of utility patent is called a provisional patent application. And those are really handy when you're about to release a product and you just found out about it as a patent attorney. It allows you 1 year of protection. The disclosure requirements are very minimal. You can basically take a cocktail napkin and send it into the patent office. Quick drawings, pictures, whatever, you're allowed to send to the patent office. The nice thing, some of my clients have us prepare a full patent application and sit on it for a year till the time it needs to be converted. This allows any improvements in the meantime to be placed into the application before it goes into a non-provisional state.
Yeah, one thing at this show, for example, all of us up here on the stage have experienced this where a client contacts us on the way to the show and says, we're going to release all of our best stuff tomorrow at the show, and none of us can remember if anyone filed any patent applications on this. Can you help us out? Well, as a patent attorney, yes, it's called a cover sheet provisional. You take whatever it is that's going to be put out at the show, you put a cover sheet on it, you file it. The next day, everybody at the show could be told everything you see here is patent pending. And you can do it with a straight face because, in fact, it is. But is that ideal? No. But we are here to help. Whatever situation you're in, we have a plan for you to get your protection started. But our advice is to try and avoid the cover sheet provisional if you can. Let's give us a little more lead time than that. Okay, Kevin, another interesting combination.
This is an example of a utility patent for a graphical user interface. I mentioned them above with respect to copyrights, but parts of a graphical user interface could also be patentable for a utility patent. In this application that I wrote, an area of the grid guide was selected and brings up a highlight from that particular sporting event.
This is for those of you that for, one sport is not enough. You can monitor the British Open while you watch football, just in case. Okay. And this is the kind of thing that people don't understand. This is an improvement on what exists. It's a combination of things. Both exist. Now they exist together. That's patentable. So just keep that in mind. All right. But hey, don't we exist in another world as well? Indeed we do. The real world is what we're in right now, but the virtual world is where a lot of activity goes on, including branding, etc. So Kevin, what's that we're looking at?
Well, we're looking at a shoe that Nike actually sells in the stores, but they have a design patent. And as we discussed earlier, they have a logo, trademark on the logo. But this slide is here just to show that design patents and trademarks exist and are enforceable in the metaverse as well.
Yeah, rights go wherever your eyeballs go and wherever your attention goes. Okay, so if you're spending hours as an avatar or your friends are, that's where the advertising is going to be, and that's where the value is going to be, and that's where your rights need to be perfected. So we protect rights that are real and those that are virtual. As they say, we can do it all. So what happens when you go out to enforce this thing, Doug?
Well, similar to the other types of intellectual property, the law allows for a variety of remedies when there is a case of patent infringement and a lawsuit is filed. Generally, in the realm of patents, we think of damages as the main remedy, and this takes various forms. The first is a reasonable royalty. The law allows for the minimum damages available to be a reasonable royalty that sets the floor. And what a reasonable royalty essentially is a number that a reasonable infringer, a reasonable patentee would arrive at in a negotiation to give access to the patented technology to the infringer. And these sorts of damages awards can lead to serious money, as with other areas of intellectual property. For example, there was a recent case where there was an order of a verdict of $525 million in damages for infringement of cloud storage patents. Another type of damages available is the patentee's lost profits, basically the amount of sales that the patentee lost due to the infringement. This requires the patentee to actually sell a product. Brings up a fairly important point. The patent is a right to exclude others from practicing technology. You don't have to actually sell your patented product in order to stop others from doing it. In the special case of design patents, infringers' profits are available as a remedy. And if an infringement was found to be willful, damages can be tripled. As with the other areas of intellectual property, injunctions to stop the infringement are available, as are border exclusions.
Now, AI. We can't not talk about AI, and artificial intelligence is going to influence everything. I have a sense in 10 years, you'll be a bunch of robots, and so will we. And I'm interested what that conversation is going to be like, a bunch of Optimus Primes on both sides of this. But until that happens, let's think about what we can do with AI and how it will affect our existence and how it affects our ability to obtain rights and protect rights. So, Kevin, tell us about your thoughts on AI.
Well, AI right now is relatively new in the patent world. The patent offices haven't examined that many cases with AI, and the law around the world is developing. But I think there's some things you can do in your patent application in order to help increase your chances to get it through the patent office. One couple things I do are try to avoid generic terms about machine learning and data analysis. And what are you really doing? These are components, specify the models, the types, the number of layers, for example, in a neural network. How you train the artificial intelligence may also be important. I've had cases where it was special feedback loops, for example, were used in the training of the AI, and tie it to the data sets as well. Also tying it to your hardware, and what happens before and after the AI are also very important to emphasize.
Another thing to think of too is, using AI and considerations there. The first point being, be careful about what you put into the AI system. And this takes a couple forms. Recall earlier, public disclosure of technology can preclude a later patent. Well, if you're disclosing technology into an open AI, non-confidential system, that could count as a public disclosure. Similarly, if you have an AI system that you're training, be cognizant of what you're putting into it. Are you opening yourself up to a copyright infringement issue? Things to be aware of. And there are people developing other tools using AI in this space. There are some that are developing AI tools where they say you can upload your patent into my AI system and it will go out and find infringers. Similarly, there are others saying you can upload a description of your technology, which you may have filed a patent on, into our system, and we'll go out and find patents you should be aware of and try to avoid. These systems aren't there yet, but we're certainly monitoring this as time goes on.
Yeah, and just a data point for all of you here, and that is that AI cannot by itself be an author, neither can it be an inventor. And these protections are for human creativity and human invention. So while we think we're going to be replaced, there's the hedge, okay? Be an inventor, be an author, be a creator. We have your back. Next, trade secrets. Here's the thing. Half of this show is going to be bought by the other half, right? Within 10 years. Those who survive and have money will buy those that didn't, and a new half will appear. All right. How do you wrap your arms around all the creativity that's occurring that's going to outpace patents and other things? You're going to use trade secrets. And so trade secrets, take it away.
So trade secrets are the fourth category of intellectual property and essentially in some ways a catch-all. A trade secret can cover any type of information that derives value from being a secret for so long as it's a secret. This would include things like sales plans, customer contacts, formulas, manufacturing information, etc. An important aspect of trade secret protection is that the protection is immediate. When the information comes into being and is kept secret, it stays immediate. The trade secret protection is immediate. No filing or registration is needed. A few caveats. You must take reasonable steps to keep it a secret, limiting access to it. If something can be reverse engineered, then if somebody does that, that's not a trade secret infringement or trade secret misappropriation. So it leads to strategy. If you have something that can be reverse engineered, you want to go patent route, not trade secret. Employee agreements are very important. You have to use those to maintain confidentiality. As with other areas, injunctions, damages, including potentially for big money, destruction of goods are available as remedies for infringement.
So why do we do anything? Money, money, money. You're not here doing this just because you love to do it, although that may include some of you, but most of you want to make money doing it. So monetizing your IP, take it away.
Yeah. So suing somebody is not the only way to monetize your IP. There are certainly many instances in many ways where you can obtain value for your IP outside of a lawsuit. One, to follow Kevin's example earlier in the presentation, fundraising, patents, and other intellectual property, trademarks, copyrights signal of value to potential investors and are very important for potential investors. Patent rights, especially copyrights, are a property right like other property rights. These can be sold. These can be licensed to others. There are certainly many instances where a company will develop technology, end up ultimately going a different route, still having patents on that technology that others are interested in. It's a potential licensing opportunity there. Patents can be used, for example, as the collateral for loans from a bank. And one other important point with patents, a lot of times people developing technology, they should do intellectual property clearance where they go out and look and make sure their technology won't infringe anybody else. Well, there are many instances where your patent may stop others as part of that process from infringing on your patent, and you'll never know that happen. But that deterrent effect is out there as well.
All right, we're getting towards our wrap-up phase, and so I'm going to give each of you 30 seconds to tell the crowd what the message is for your take-home. What is it that you want them to leave here remembering today?
My main thing is get it on file. Get your patents on file so you preserve your foreign rights and your U.S. rights prior to releasing an invention.
Doug?
Yeah, my takeaway is that, certainly you can sue for infringement of your intellectual property rights. That's not the only way to obtain value from those rights. The slide here shows many examples of ways that IP rights could be monetized and otherwise used to further your competitive position, and these don't require a lawsuit. Conversely, it's important when you're developing technology to make sure that you're doing what you can to find out what intellectual property is out there and do what you can to avoid stepping on that, because as we've seen, lawsuits can lead to significant remedies.
Right. And the take home that I'd like you to have is get to know your patent attorneys and those who give you advice, because the scene changes. This year, for example, there's legislation being proposed that would make almost all of software patentable again. It hasn't been for the better part of a decade or slightly more. And so that's going to come back, and we expect that to happen sometime in calendar 2025. And so we get to our last slide, which is, have you ever seen $600 million? Well, here's a way you can carry it in your pocket. In fact, all of you do. The phone on the left is Apple's. The phone on the right is Samsung. One was worth $600 million. Can you guess which one? Now, We all believe Apple has enough. Well, they have more. And so they got it with a design patent. By golly, $2,500 turns into 600 million. Thanks for coming.